be seated. Are the parties ready on Stinson versus State of Florida? May proceed.
I would like to reserve 3 minutes for rebuttal. May it please the Court, my name is MJ Lord. I'm here from the Public Defender's Office on behalf of Ms. Stinson, the appellant in this case, who is convicted of the second-degree murder of...
MJ, I'm sorry, can you put the microphone closer here?
Closer? Okay. Actually, maybe I need to move this up a little bit. Okay. Should I start over?
No, you can go.
Okay. The major issue in this case, I believe, is the question of self-defense. And in order to address that, there are 4 areas that I had in mind to address with the Court. The first is the defense obligation to put on a prima facie case of self-defense. The second is the state's burden in response to present inconsistent rebuttal evidence. The third topic I want to address is the Rasley case from this Court. And the fourth is the recent Montgomery case from this Court. On the first topic, we're dealing with a well-established line of cases and a well-established rule that when the defense presents a prima facie case of self-defense, the state must rebut with conflicting evidence inconsistent with the defendant's theory.
Okay, I think we can agree with what the law basically is. But how do you get around Rasley versus State?
Okay, I will go straight to that one. Let me first note that in one of the cases I cited in my brief, which is Jenkins versus State, it does note that self-defense cases are intensely fact-specific necessarily. I think that this case can be distinguished from Rasley. I recognize that there are some things that it has in common with it. However, in this case, at the critical moment, Mr. Stinson had pointed a gun at Ms. Stinson. He had already hit her. She was on the ground. He had, at times, threatened to kill her. And she did not have any way to retreat from that situation, as did Ms. Rasley.
According to her.
Yes.
No reason to
yes,
retreat.
but I don't know what other evidence there is of what was going on at that particular moment. I mean, she's on the ground. Ms. Rasley, on the other hand, in the opinion from this court, the court noted that she, in addition, there's no evidence that my client armed herself before she went out to confront her husband. But there was evidence in Rasley that she retrieved a gun after her husband was attempting to re-enter the house following an altercation. There's also some interesting evidence in Rasley that says the victim was found dead next to the open side door of the house, which is ambiguous, I guess, at best, and that the shot that killed him was fired from 24 to 48 inches, or 42 inches from his head. The court concluded in that...
In Rasley, were there any evidence, any statements made by the husband threatening the defendant as he approached her?
In this case?
In Rasley. Were there any threats by the husband, I'll kill you, or anything to that effect? I
don't know, Your Honor. I'll look at the opinion before my rebuttal and address that then. Anyway, the court's general conclusion in Rasley was that because the record in our judgment contained sufficient evidence from which the jury could conclude that the defendant had other reasonable options besides that of deadly force to avoid the danger posed by her husband's advance, including retreat, we agree that the lower court did not err in denying the JOA motion. And I don't think that's the case here. I don't think there was any showing that she could have, from where she was at that moment, retreated from the situation.
Okay, in Rasley, they talk about the fact that she had just found out that her husband had been cheating on her.
Right.
And that was the major thing they seemed to glom onto as far as being inconsistent with the self-defense theory. Mm-hmm. They really glommed onto the motive.
They did.
Here we have, she had found a condom in the car a couple days before, so
right.
Arguably you had the motive here.
Right.
You had inconsistent statements or statements that turned out to be untrue to the police, at least two or three of them,
Right.
and hiding the gun. So isn't that a lot more that would be inconsistent with self-defense?
Actually, I think it's also important, Judge Wolf, when you're looking at that question, to look at the Jenkins case, which is cited in my brief, which says that the self-defense issue does not arise until the defendant is faced with the use of force. And you've got to look at that moment, what's happening at that moment. I mean, there's no doubt that things had happened that upset Ms. Stinson, and that she went out to the garage intending to talk to her husband, to confront him, to tell him she wanted to end the marriage and that he had to leave. But that's not what you look at. You look at what was going on when she was on the ground and felt so threatened that she believed it was his life or hers. And I think that that's one of the...
Because it almost seems to me when you're talking about looking about what was going on, either you need an eyewitness or you need some physical evidence to sustain a conviction if you have a claim to self-defense. Is that true?
Well, in a number of the cases that I've cited, Fowler and Andrews, I think, the defendants were the only eyewitnesses to what happened. And they presented their case, they presented a prima facie case of self-defense, and it was then up to the state to present evidence inconsistent with their story.
Okay, but to have evidence that's inconsistent with their story, do you need physical evidence? Do you need eyewitness testimony? Isn't the fact that somebody lies to the police inconsistent with a theory of self-defense?
Well, my argument on that is it was a bad idea, but she explained why she did it. She was in a panic. It was probably the most traumatic thing that had ever happened to her. And at the moment she called 911 and, first presented her story, she didn't really know what had happened. She was in a panic, and I think it's similar to the Fowler case where the defendant was presenting his case of self-defense, and he initially probably didn't do the right thing. He took off, but he explained he was in a panic, he didn't use his best judgment, and I think the same thing applies here.
So, counsel, you would agree that the appellant's actions after the shooting did cast considerable suspicion upon her?
Yes, but suspicion's not enough, and the Fowler case addresses that too.
Were the nature of the wounds that the ME talked about, or were those inconsistent?
No, they were not. The medical examiner said, he was asked by defense counsel, could those wounds have been inflicted if he was coming towards the person shooting him? And he said yes. And he also said
The bullet that went through
there was one to the front and one to the back, but she was on the ground and he was coming towards her. And I believe he also said there were a lot of scenarios that could have happened, but he did answer that question, that it could have happened as he approached the person shooting him.
Did he form any opinions regarding the shot to the back of the head?
Well, he did say that was the fatal shot, but no, he could not say what the relative positions of the shooter and the victim were based on the injuries.
We have a Fowler case out of the first DCA and a
Right.
Fowler case out of the second DCA.
That's right.
Are Fowler out of the first DCA and Rassley, can they be harmonized, or are they?
I don't recall at the moment if the first DCA's Fowler is cited in Rassley. I'll have to look at that. But
I don't believe it was cited. I don't think so.
I have to say, Judge Wolf, that I have some concerns about Rassley because I think that the appropriate test here was set forth in the first DCA's Fowler case and in the second DCA's Fowler case, and that is, in a self-defense case, evidence that leaves room for two or more inferences of fact, at least one of which is consistent with the defendant's hypothesis of innocence, is not legally sufficient to make a case for the jury. And I am concerned that when you read Rassley, it seems inconsistent with that principle. I have a few more minutes. Let me just go back and mention a couple things that I wanted to highlight. I did submit a couple cases as supplemental authority last week. One of them was some useful language on what exactly has to be presented by the defendant to prove its prima facie case of self-defense. This is in the Fields case. And the language is that the law does not require the defendant to prove self-defense to any standard measuring assurance of truth, exigency, near certainty, or even mere probability. Defendant's only burden is to offer facts from which his resort to force could have been reasonable. And I've already mentioned.
At this time, can you distinguish the Rasley case from this case on the facts?
On the facts?
Yes.
Yes.
That
Yeah, that was what I was attempting to do. I think you have to look at the moment at which she was truly threatened, and could she retreat? And on that alone, you can distinguish it. Because this court said Ms. Rasley had the opportunity to retreat. She was inside her house. But apparently, from my reading of the case, what happened right at the door as he was coming back in, and I guess she could have gone through the house and escaped. But given what we know about what happened here, that this woman was first, had a gun pointed at her, had been threatened that he would kill her, she had been hit, she had been knocked down, she was on the floor. And at that point, I don't really think that she had an opportunity, that there's evidence that she had an opportunity to retreat from that situation. I did want to mention to the court also, because I found it interesting, was that at trial, after the defense moved for the JOA after presenting its case, the state did not present an argument. It did not explain what its theory was of how its evidence was inconsistent with the claim of self-defense. The judge just ruled on it without taking any argument on that.
And I don't want to lose sight of the jury instruction issue either.
I'm sorry.
The jury instruction issue. The jury instruction issue. I don't want to
Montgomery?
Montgomery.
Yes. Well, this court recently decided that the manslaughter, standard jury instruction on manslaughter is a problem, and certified conflict with one of the other DCAs, and also a question of great public importance. I don't believe there's any way to factually distinguish Montgomery from this case based on a reading of that case. Also, the court has cited it in 2 other cases subsequently. So I think at this point there's really no choice but to follow Montgomery if you reach that issue. Thank you.
3 minutes.
May it please the court, Michael Kennett for the state of Florida. The appellant raises 4 issues. First issue is the trial court's denial of the motion for JOA as to the self-defense.
Well, help me on that one. First of all, can our case in Fowler be harmonized with the decision in Rasley?
No, sir. And as the state pointed out in its answer brief, law essentially overrules Fowler. The language that the appellant cited from Fowler is this, that evidence that leaves room for 2 or more inferences of fact, at least one of which is consistent with the defendant's hypothesis of innocence, is not legally sufficient to make a case for the jury. That seems to suggest that if there's a tie, that the case does not go to the jury. But law says the exact opposite. Law says that all the state needs to do is to introduce evidence inconsistent with the defendant's theory of events.
Okay, and what specifically in this case is inconsistent with the defendant's theory of defense?
Well, there are lots of things, sir. But the most salient, 2 shots, one to the back of the head at a downward angle. That clearly belies a claim of self-defense. It's inconsistent with the defense hypothesis of innocence.
But the ME said it wasn't.
Yes, sir. But again, we're looking at, you're looking at the evidence in the light most favorable to the state. It is the fact that the appellant shot the victim twice, once to the back of the head, inconsistent with self-defense.
Why shouldn't you be bound by your expert, though? I mean, this is the state's expert, ME, who said that the method that these bullets entered the body was not inconsistent with the defendant's theory of defense.
That's fine, but that goes to the weight of the evidence, sir, not to the sufficiency. We're talking with a judgment of acquittal where the state is entitled to a view of the evidence in the light most favorable to it. Is there competent and substantial evidence from which a jury could fairly and reasonably infer the appellant's guilt. Because this case involves evidence that is circumstantial, is there evidence inconsistent? And it is. Now, what you refer to, sir, an expert saying that, yes, the second shot must have been from behind, it would not have been, that would go to the weight of the evidence. That's a question of fact for the jury. Did this person act in self-defense? But the second shot is inconsistent with a theory of self-defense. But there's other evidence as well. The murder weapon, the .38 caliber revolver, was hidden in a baby's room. That is inconsistent with a theory of self-defense.
What did the record say about how far apart the shots were? Were they close together in time, or were they a second apart, 2 seconds apart?
Well, it's
within a second.
It's unclear, sir. One of the neighbors heard 2 bangs, or 2 loud noises that the neighbor thought were gunshots. There is no scientific evidence, so to speak, or there's no evidence pinning down the time in between shots. There is some testimony about the trigger pull. The trigger pull on the initial would have been about 11 pounds. On the second, not as much. So the second shot could have been quick. That's true. But
the other evidence here, other than the shooting pattern, I understand your argument there, but the evidence of hiding the weapon or concealing the weapon, according to the second district, that kind of stuff where somebody exercises poor judgment and panics and hides that is not necessarily inconsistent with self-defense. I'm talking about the Fowler case of the second DCA.
yes, if that's all that there is, if all you have is this after-the-fact attempt to cover up, then perhaps that would not be inconsistent. This court has not said so, but in this case, it doesn't matter because we have so much more than just this strange behavior after the shooting. If that was all that we had, perhaps the appellant would have a stronger argument on that point.
Okay, we interrupted you. Go through everything you think is inconsistent with self-defense.
Sure. Lying about the .38 caliber revolver, lying to the police. When she initially called 911, she didn't say, "I just shot my husband. He tried to kill me." And that's an important fact because she testified that she was so afraid of him that she had to shoot him twice, once to the neck, second time to the back of the head, that she had to lock all the doors and lock all the windows. She was that terrified of him. But wouldn't it seem reasonable that if you were that afraid of someone who just tried to kill you, that you would call the police and say, "Please come to my house as soon as you can. There's a madman who's trying to kill me"? She didn't do that. That is entirely inconsistent with self-defense. By her own testimony, she didn't know what happened to him. She didn't know that she had shot him fatally to the back of the head, that a bullet had rattled around inside his abdomen, piercing many vital organs, causing him to bleed to death. She didn't know where he was. Wouldn't you think if she was that afraid, she would call the police and say, "Get here as soon as you can. My life is in danger"? She did not do that. She lied. She didn't call right away. And the evidence suggests that the only way she called the second time is because her daughter woke up. So she lies and says, "I was asleep. I heard these 2 loud bangs. I walked around my house. I can't find my husband. His car's in the garage. The garage door is open. I don't know where he is." A complete lie. But even her own version of events doesn't make sense. She says that she is standing with her back to the open garage door, with the driveway and the cul-de-sac behind her, and that he is facing her. Her version of events is she shoots him twice. One shot to the back of the head that was fatal, yet he still has enough to bowl her over and run out that open garage door into the street.
Testimony she was on the ground, though?
Yes, but he still bowled her over, went over her to go out. There was no blood on any of her clothes, nothing like that. Her own story doesn't make sense. So when you look at the totality of all those circumstances, surely the state's case is inconsistent with the defense theory of self-defense. That the defense theory, whether or not it was reasonable, it was a question of fact that the jury should rightly decide, and they did decide. They were the ones there. They were the ones who saw the demeanor of the appellant when she was under cross-examination. All the state needed to do was present evidence inconsistent. The state did that. And moving on to issue 2, although not mentioned in the answer brief, that issue is unpreserved because the appellant only filed a boilerplate motion.
Counsel, let's backtrack to the Rassley case. You essentially relied on the Rassley case. Is that correct?
Yes, sir.
Okay. In the Ronsley case, looking at the opinion itself and where the court sets forth the facts, it says, following a shouting match, the husband left the house only to return shortly thereafter, unlocking the door, which the appellant had double locked when the husband left. At that point, the appellant obtained a Colt .357 Magnum revolver, a firearm which she claimed she had never before discharged. Despite her entreaties for him to stop, the husband continued his advance toward her, whereupon, in an act she claimed of self-defense, she fired the weapon once at a distance of 24 to 42 feet. Now, in response to that, we noted that because the record in our judgment contains sufficient evidence from which the jury could conclude that an appellant had other reasonable options besides that of deadly force to avoid the danger posed by her husband's advance, including retreat, we agree that the lower court did not err in denying the motion for JOA. In our case, regarding the testimony of the appellant in the proceedings below, in terms of the direct examination by counsel, what did your husband say to you when you pointed the gun at him? He told me that I wasn't going to do anything to him and that he was going to take the gun from me and kill me with it. At that point then in time, did he make any movements towards you when he said that he was going to take that gun from you and then kill you? Response: yes. That's when he lunged for me. That's when I pulled the trigger. Now, statements by the husband in our case were made in terms of he's going to kill her. And there were no statements in Rasley from the husband regarding he was going to kill the wife. Don't you think that would make our facts a little bit distinguishable from the facts in Rasley?
No, sir.
Why not?
Well, the first thing is that's self-serving testimony. And the second thing is there is no physical evidence to support.
There's nothing in the record to contradict that testimony, is there?
Well, I would point you to some facts in Rasley. There was actual evidence of a physical struggle in Rasley.
Is there anything in the record to contradict that direct evidence by the appellant?
Well, we have evidence of motive. We have 2 shots, one in the back of the head. Things that she did afterward that are entirely inconsistent with acting in self-defense. Lying to the police, not calling 911 to ask for their protection, hiding the weapon, lying about it, repeatedly lying to the police. An actual factual scenario that makes no sense. You mentioned retreat, sir. By her own story, she had an open garage door behind her. She has the gun. She is facing her husband. He threatens her. The garage door is open behind her. It is self-serving, and the lack of any physical evidence to corroborate that shows that it is self-serving. Not only that, there is evidence inconsistent wholly with her story. And it is just that. It is a story concocted after the fact to hide what she did, which is a crime of murder. And that is what the jury found.
Okay, if you get her past the judgment of acquittal argument, we're still facing the Montgomery argument.
Yes, sir.
And, obviously the relief there is a little bit different. It will be a new trial versus an acquittal. How do you get around Montgomery? And the 2 cases that we've cited since then, saying the instructions that the jury was given in this case constitute fundamental error.
Yes, sir. For a jury instruction to constitute fundamental error without any analysis of the facts of the case, 2 things must be present. 1, the instruction must fail to define or incorrectly define a disputed element, that's the first thing, of the crime of conviction. Those are the 2 important conditions, and neither of those is present in this case.
Wait a second. The question of whether this woman intended to kill this man, isn't that a basic dispute of this case?
No, sir, it's not, because she claims self-defense. And by asserting self-defense, she admits all the acts. She intentionally shot her husband because she was in fear of life.
There's a difference between intending to shoot and intending to kill.
Okay,
and
sir.
She could, admittedly, she admits she intended to shoot. That's part of her self-defense. But I don't think she ever said specifically, I intended to kill him when I shot.
If there was only one shot, sir, then the appellant would have a stronger argument that she used deadly force
But
simply
if
to
she has
immobilize.
any argument as to whether she intended to kill this person, if there was any argument at all that could be made, then don't you have a problem with that instruction?
No, sir. No, because
Well, wait a second here. As I understand the argument, the problem with the instruction is that because the instruction seems to imply that you have to intend to kill to have a conviction of manslaughter, and that is an incorrect statement of the law, the jury may not convict somebody of manslaughter. So why is that not one of the very issues in this case? What she intended to do?
again, it goes back to the self-defense. In Montgomery, this court relies upon Hankerson and the concern that an incorrect instruction on a lesser-included offense precluded the jury from considering that lesser-included offense. But if the jury in this case misread the instruction as the appellant argues it did, which is to read into manslaughter by act and intentional killing, the facts of this case show that. We have essentially a confession. And that's, in the Martinez case, the Florida Supreme Court cited back to...
The facts of this case conclusively show that she intended to kill him?
Yes, sir. And again...
And where do we get that from?
First, from the claim of self-defense, that she intentionally shot him. And I understand your point that, well, maybe she used deadly force just to immobilize him. If there was only one shot, that would be a strong argument.
How many rounds did the revolver hold?
There were 6, sir. There were, I believe, 6. 2 were...
So why didn't she shoot them all if she intended to kill him?
Well, once you shoot... Well, that second shot was to the back of the head, and it was indeed a fatal blow.
Wait, as I understand...
Apparently he ran off. It didn't appear too fatal.
And she didn't call the police. He languished out there on the street for 20 to 30 minutes.
Okay, you're making arguments as that you did intend to kill him, but why isn't the argument available that I shot him twice because he kept on coming toward me? I mean, that's her argument. He kept on coming toward me. I shot once, he kept on coming. I shot again. How do we know conclusively that she just did not intend to immobilize him rather than kill him?
And I would say it's a second shot to the back of the head, sir. But...
And I understand that, but at your own ME, I mean, normally a shot in the back of the head is problematic. But your own ME says, as he was falling, the position she was in on the floor, as he was falling from the first shot, could have gone in like this, as he's falling. It's not somebody being turned around. It's not somebody still not coming toward the victim. It appears that your own ME's testimony could be that this would be consistent with self-defense, consistent with not intending to kill this person, but just to immobilize him.
It's consistent with two views. It is, sir. But there are other problems with the Montgomery decision, sir. And that is, it has a per se rule of reversal. It finds fundamental error without conducting analysis into the complete record. And the Florida Supreme Court has said repeatedly, especially in the context of jury instructions, that per se rules of reversal, they've retreated from that time and time again. Even this court, in the concurring opinion in Riley, talked about the folly of inflexible rules.
The concurring opinion in Riley that I wrote, I don't particularly like per se reversible error. But here, I don't see, you still have to conduct some kind of harmless error analysis.
No,
and I don't see how you argue that beyond a reasonable doubt that the jury could not have found comeback manslaughter if they were instructed properly.
I would say, first, sir, it's not harmless error analysis because there is not a preserved issue here. We're talking about an unpreserved issue. Harmless error analysis only applies if there's a preservation. We're talking about fundamental error, which is higher. The Florida Supreme Court said very clearly, all fundamental error is harmful, but not all harmful error is fundamental. It is harder for the appellant to demonstrate fundamental error than it is for the state to show that the error was harmless. We're talking about an error so egregious as to deprive an appellant of due process.
Which this court 3 times has said exists when you wrongfully instruct as manslaughter in this manner. Okay, your time is run.
Thank you for your time, sir.
Judge Lewis, you had asked, I believe, if in Rasley the victim said anything just before the shooting to Ms. Rasley, and I went back and looked at the opinion, and I don't, while they had an argument earlier on, that was earlier on, and when he came back, I don't see in the opinion that he said anything in particular to her. On Montgomery, I just wanted to point out to the court that the jury did deliberate for quite a while in this case, and they did ask a question about, I believe, what is required for a depraved mind. So they did have some questions. And I still think that this panel probably has to follow Montgomery as it is at the moment.
Okay, tell me again on Rassley. One question, because it came up during argument. I hadn't thought about it earlier. Her testimony was that she was closer to the street or, the garage door than her husband was originally.
In my case.
In your case.
She was, yes, I think she was back, and he was closer to the house.
He was closer to the house.
Yeah.
And you said in in the other case, she could have retreated.
Through the house,
Through the house.
I mean, that's...
But why couldn't she have retreated here, out?
Well, she was on the ground, for one thing. I mean, she's right there faced with this guy who's going to take the gun away from her and shoot her. I mean, and that's the evidence we have. This other one, you have the court saying for some reason that this guy was found right at the door and that she armed herself. And I'm just, from that I gather that she could have gone through the house and just gotten away. But I don't think you have the same thing here. I also think that the law as set forth in Fowler, both DCA's Fowlers, is still correct, and I sent a November 2008 case up to the court that relies on that language. My recollection of the record is that the neighbor who said anything about how quickly, that you would use to determine how quickly the shots were fired, was he heard pop, pop, which to me indicates it was, one shot right after the other. I believe the record shows that Ms. Stinson called 911 immediately. I don't know why it took them 20 to 25 minutes to arrive, but she called again. I don't think she delayed or did anything from which you can infer that she wanted to leave him out there. And another reason on the issue of retreat, there were 2 small children in that house. If there are no further questions, thank you for your time.
Thank you. Okay, well, counsel in the next case can wait